And members, this bill does what you said. It addresses both the security of the governor and it protects deliberative process privilege. And in opening, I'd like to start by addressing the deliberative process privilege by citing a couple of court cases. Kyle versus Louisiana Public Service Commission in 2004, the First Circuit cited in their analysis that the deliberative process privilege is unique to government and has a number of purposes. It serves to assure that subordinates, staff within an agency, will feel free to provide the decision maker with their uninhibited opinions and recommendation without fear of later being subject to public ridicule or criticism. It also is used to protect against the premature disclosure of proposed policies before they have been finally formulated or adopted, and to protect against confusing the issues and misleading the public by dissemination of documents suggesting reasons and rationales for a course of action which were not, in fact, the ultimate reasons for the agency's action. They go further to say, thus, the privilege protects documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. And back to deliberative process. Basically, the bill addresses public records requests as they pertain to deliberative process, just as the courts have declared the exceptions and exemptions. So I did not make the definitions. The courts did, and by putting them in state statute, we're providing clarity to the public, as we've recognized as a legislature we should. And so without any further explanation, that's basically what the bill does.
And so if this bill appears to be directed to the governor, so what is to stop any other statewide elected official from seeking the same protection, or should they be entitled to the same?
Yes, sir. The security is pertaining to the governor. The deliberative process privilege is pertaining to all government agencies.
So that's something to consider, okay?
Yeah, but we can't erase jurisprudence. That's the thing, that we tend to forget. Like, the jurisprudence is there. The United States Supreme Court has already ruled this. We're just putting it in statute. So, hey.
So, how will the release of information change on August the 2nd if your bill passes differently than the release of information today?
That is a great question. It will not change.
Okay. Well, I'll look forward to hearing from others on that topic too, but I just wanted to clarify that point based on some of our prior conversations, that I thought that you were not attempting to disrupt the process of release. You were attempting to streamline. That's right, but it sure sells newspapers, though.
All right, please proceed, sir.
Mr. Chairman and members, I'm Tom Jones from the Attorney General's office. I've put in a green card to indicate the Attorney General's support for this bill.
Identify yourself for the record and you may proceed.
Vicki Milius with Lieutenant Governor Billy Young-Yester's office. He was not able to attend today, but asked us to come give a statement in his place. He is at a meeting today in Jefferson Parish. However, he fully supports Senator Cloud's proposed legislation and wants